versus Green Bandit Lawn Care. Counsel, if you're ready, you may proceed.
Good morning, Your Honors. May it please the Court. My name is Mike Weiner. I'm here on behalf of the claimant, appellant Elizabeth Lyon Hall, who is the court-appointed guardian for an injured worker by the name of Alejandro Lopez, who was rendered completely incapacitated as a result of a work injury that he sustained. I would like to please reserve 6 minutes for rebuttal.
Okay, so noted.
So the case starts with very tragic circumstances. On February 11th, 2021, Mr. Lopez was working as a landscaper for his employer in the course and scope of his employment, edging around a pool, when for unknown reasons he fell into the pool. Unfortunately for Mr. Lopez, he never learned how to swim, and as a result, some 30-40 minutes later, his coworkers found him at the bottom of the pool. They fished him out. He was taken immediately to the emergency room, but it became quickly apparent to all persons concerned, including the carrier, that this gentleman had suffered very serious injuries that would render him now and forever in a permanent vegetative state. So the carrier knew from the very outset of the case, within 1 or 2 days after having received notice of the injury, that they were dealing with the claimant who was completely incapacitated, who had no ability to make any medical decisions on his own, who had no ability to receive indemnity benefits on his own or do anything on his own behalf. Curiously, though, even though the carrier was armed with this knowledge, just 4 days after the accident, it marched into the Judge of Compensation Claims office on an ex parte hearing solely for the purposes of wanting to obtain and preserve blood and alcohol, blood samples regarding the injured worker. So we see at the very outset that the carrier's motivation was not how do we take care of this injured worker, but really, unfortunately, is there a possibility that we can deny this claim based on an intoxication defense?
Would it have made any difference if they had not taken that action, if they had immediately gone to the JCC and sought a guardianship for Mr. Lopez?
Well, I think under the self-executing nature of the workers' compensation law, that's what the carrier should have at least done. We're not saying that the carrier had the responsibility of filing all the papers, but at least alert the judge and say, hey, Your Honor, 44017 says that you have, a discretionary authority to go ahead and appoint a guardian for a totally incapacitated person.
Does the JCC have the authority to appoint a guardian?
Well, the JCC, it says it can appoint somebody to receive the benefits. There are two separate guardianship concepts here. We talk about 440.17 in terms of a guardian in the context of workers' comp, but then there's the separate guardianship provisions that exist elsewhere in the Florida statutes, and those are the protocols that we were compelled to follow because the carrier never did anything to sort of assist Mr. Lopez with having somebody who could be the legally proper person to receive his workers' compensation benefits and to make medical determinations on his behalf.
Well, I'm glad you mentioned the guardianship statute because, certainly the provision for appointing a guardian under 440 or seeking the appointment of a guardian does not operate independently from 744. Isn't that correct?
Correct. I think they're supposed to be sort of read harmoniously with each other, and that was obviously not done in this case.
Right. Well, and correct the court if the court is incorrect about this, but was there not an uncle who was involved who purported to receive indemnity benefits early on in this case?
Yeah, there was an uncle the carrier had reached out to early on in the case, and he sort of, with just a quick telephone call with no real investigation as to whether the uncle met any of the legal requirements to serve as in the capacity of a guardian, and he just said, I'll be handling everything for the injured worker for now.
Okay, so understanding the facts then, we get to the appointment of a guardian. The guardian here was appointed under 744, correct?
Correct.
All right, and doesn't that chapter also provide for the payment of costs and fees to a guardian and how those should be obtained?
Correct.
And are fees for a guardian, are those submitted to a JCC for determination or for the court, with the court being defined under 744 as the circuit court?
Procedurally, to answer your question, excuse me, it's a good one. The guardian would have to petition the guardianship court for payment for her services. In other words, that I've had to go out and spend X number of hours to provide benefits on behalf of the ward. That gets approved by the guardianship court, and then the judge of compensation claims in turn is given the authority and the jurisdiction to order reimbursement from the carrier to the claimant. And that's exactly what we've sought here, and that's where we assert that the judge committed legal error by failing to reimburse the claimant for the guardianship expenses that he incurred as a result of being able to set the guardianship up on behalf of the ward.
And to be clear also, the expenses that were incurred by the guardian were not expenses that were incurred for filing a petition to secure compensation for the ward or to secure some other type of benefit that was not already being provided by the employer.
That is correct, Your Honor. This was sort of what I call the ab initio, right? You got to have the egg needs to come first before the chicken in this metaphor, right?
So the administrative costs of the guardianship.
Correct.
Right.
Correct.
So, all right. And so stay with me then. It seems that Chapter 744 anticipates those very expenses to be incurred under that chapter. And in fact, it imposes on the guardian certain duties, including, marshaling the assets, accounting for the assets, also to seek and make provision for the medical care of the ward. So those are all 744 obligations, administrative obligations of the guardian. So why should those costs and expenses not be awarded under 744 as they are with any other professional guardian?
Well, they are awarded by the guardianship court under that chapter to the guardian. And now the guardian turns around and seeks reimbursement from the workers' compensation carrier for reimbursement for those services under 440.17. So our position is that it is an incorrect reading of the statute, as well as, more importantly, the case law, which is there's really three cases that have interpreted. We've got Lavoie, Charlton, and then the Valdez case, to a lesser extent, interpreted this. Interestingly enough, in both the Lavoie and the Charlton case, you can read between the lines and sort of see that the establishment of the guardianship seems to be fees or expenses that were awarded by the JCC and approved by this court. It's the ancillary matters, right, that where the problems come into and the questions come in. In Lavoie, for instance, the court talks about the guardian performed a variety of services for Lavoie in addition to pursuing the claim. So, there's a whole universe of things out there. In Charlton, there was this issue of, criminal court proceedings, which the guardian was compelled to attend, which this court said, no, you can't get those. And what I think the Valdez case did is sort of put a nice little bow on this and interpreted these cases as saying, okay, there has to be an inherent link between whatever the services are that the guardian are providing and the workers' compensation case, right? And we've heard this sort of, this causation sort of link exists everywhere in workers' compensation, whether we talk about major contributing cause, whether we even talk about advances, and there having to be a plausible nexus for the need to it, for the advance with the work injury. And, the Valdez case talks about this necessity of an inherent link. And we would submit to you that under that decision, as well as under Lavoie and under Charlton, there is absolutely, undeniably an inherent link between the workers' compensation case and his injury and the services that the guardian provided.
But how is that different than, let's say, a personal injury suit where an insurer, compensates a plaintiff who has been injured in the way that the workers' compensation system does, and then the guardian is paid under the authority of the 744 from the assets of the ward. And so here, the ward received indemnity benefits that the guardian is administering. Typically, with that kind of income and asset available, the guardian would seek reimbursement under 744 with the approval of the circuit court. Why isn't that the correct method for recovering these administrative costs and the costs of, making sure that the ward is getting the medical care he's entitled to?
Well, I would submit to you that in a personal injury case, part of the damages that can be claimed would be the damages of the expenses for the guardian. Those are things that you would sue as part of your economic damages against the tortfeasor, and then you would presumably be awarded those by the jury or by the court. And so that's all subsumed in what you get. So again, does the ward individually pay them? Yes, but he pays them only because he's been given the full right of his recovery, assuming he makes his recovery, as part of his. Those are part of what his damages are. And I don't think workers' comp really operates any differently.
One final question for me, and I know that my panel members may have others. So how is this to work? Does the guardian first get approval from the JCC for the costs that have been incurred and then go back to the guardianship court? I mean, 744 is clear that there needs to be approval by the circuit court. So is there kind of like a double process here?
So it is a double process, and it's a good question. And I think the way it is intended to operate and the way we've seen it operate, and this is kind of spelled out a little bit in Lavoie. In Lavoie, you see that the attorney went to the guardianship court. In the circuit court order, there was $8,500 in guardianship court, and guardian fees and costs, et cetera, that were awarded. Then the claimant went to the judge of compensation claim and said, I want that back. And this court said, you get part of it back, but you don't get all of it back, right? In other words, the judge of compensation claims role upon the guardianship court approving these fees and costs and expenses being paid to the guardian is to say, okay, what is it that's, has an inherent link to the workers' compensation injury? Which of these tasks that the guardianship court has approved payment for are related to the handling of the ward's right, responsibilities, and duties under Chapter 440, including but not limited to. And this is where we think the judge made a huge mistake, right? Because the judge treated this as a just these things and these things only. But in Charlton and Lavoie, it talks very clearly about including but not limited to. So there are a whole other set of things. But the things that this court gave an example are collection of benefits under Chapter 440. Unquestionably, that's what Ms. Lionhall did here. Number two, obtaining medical services for the claimant. That's exactly what she did here. You don't have to have denied medical care to require the need of the guardian to be able to supervise and make sure the claimant's getting proper medical care. And then last but not least, obviously, representation of the claimant and claims or proceedings before the JCC. Save the rest of my time for rebuttal,
Thank you, counsel.
unless there's any other questions. No?
May it please the courts. Good morning, Your Honors. My name is Allison McInvale, and I'm here today on behalf of the appellee, the employer, Green Bandit Lawn Care, and its workers' compensation insurance company, FCBI, and their servicing agent, USIS. Your Honors should affirm the judge of compensation claims order because the appellant failed to preserve her objections to the order. Appellant argues in her reply brief that she made the same arguments at trial as she did in her initial brief, which is true. In fact, in some parts, it's verbatim from the trial memorandum submitted prior to final hearing and the initial brief, it's word for word. However, what appellant is appealing here is the judge's final compensation order. That is what's at issue here. An appellant is taking the position that the judge of compensation claims made errors in that final compensation order. And the case law, specifically the Hamilton case, the Holland case, and the Jellison case, all direct in workers' compensation matters, that to the extent there's a reviewable issue that arises for the first time in the final compensation order, that the appellant has the obligation to present to the judge of compensation claims in a meaningful way the objection to that order. And the purpose of this, Your Honors, is to prevent parties from taking advantage of the appellate process without allowing the judge of compensation claims the opportunity to address the errors perceived in the final compensation order. In workers' compensation matters, there's a procedure for this. It's found in the Florida Administrative Code at 60Q-6.122. And it instructs that a motion for rehearing be filed if two circumstances exist. One, to challenge rulings that were outside the scope of the issues presented, or two, most applicable in this matter, to seek clarifications in matters of law or fact that the judge might have overlooked or misapprehended. Here, appellant failed to file a motion for rehearing or otherwise bring her objections to the final compensation order to the judge's attention before filing the instant notice of appeal. There's no way appellant could have raised her objection to the order before it was entered. So to argue the appellant made the same arguments below that they're making here now in the appeal makes no sense, because how can you argue a perceived error in a final compensation order before it even comes out? If you're going to argue that the judge made a mistake in the final compensation order, whether in fact or law, it is the appellant's obligation to bring that to the judge of compensation claims' attention so that he or she may address the perceived error if appropriate. In appellant's initial brief, appellant states multiple times that it's appellant's opinion that the judge of compensation claims erred, and I'm quoting from the initial brief, erred in not awarding guardian fees, or incorrectly treated the guardian services as if they were taxable costs, or erred as a matter of law, or erroneously interpreted 440.17, or erred because the judge imposed a new test for reimbursement of guardian fees, or the judge imposed the wrong legal test. The judge misapplied Charlton. The judge misapplied Lavoie. These are all statements that come directly from the appellant's initial brief. The appellant also claimed that the judge erred by failing to consider certain facts as to the handling of the injured worker's rights. Appellant even argued for de novo review because it's appellant's position that the judge of compensation claims misapplied the law, specifically 440.17, the Charlton case, and the Lavoie case. These are exactly the reasons why a party would file a motion for rehearing under 60Q-6.122, to point out to the judge of compensation claims that he or she made an error either in facts or in law to be addressed before filing an appeal. Therefore, to the extent the appellant is taking the position that the judge overlooked facts or overlooked law or misapprehended or misapplied the facts or law, or seeking any kind of clarification to the order, the appellant should have filed a motion for rehearing before coming here today. And there's no record evidence the appellant filed any kind of motion for rehearing.
On the merits, under what circumstances is it appropriate for a JCC to award costs or fees to a professional guardian?
Yes, and the Charlton and Lavoie cases speak directly to that point, Your Honor. Under the Charlton case, this court held that guardianship fees are awardable only to the extent they are incurred in and about the handling of the claimant's rights, duties, and responsibilities, including but not limited to such activities as the collection of benefits, obtaining medical services for the claimant, and representation of the claimant in proceedings before the JCC. In the Lavoie case, this court instructed that employer carrier, or instructed the judge of compensation claims to address to determine what guardian fees would be payable for services the guardian performed in the course of pursuing that injured worker's benefits. And those are the words the judge of compensation claims relied on in his order. The fact of the matter is there is absolutely no record evidence of any activity pursuing or obtaining any benefit on behalf of Mr. Lopez engaged by the guardian. And in fact, the guardian failed to meet her burden of proving that she pursued or obtained any benefit on behalf of Mr. Lopez. The record is clear and it's uncontroverted that the Workers' Compensation Insurance Company never withheld any benefit, never denied any benefit. They've been providing benefits to Mr. Lopez since day one. He continues to be in a long-term care hospital that the insurance company continues to pay for every single day, providing every need since the date of the accident, now nearly 2 years ago. The judge of compensation claims found that the insurance company provided benefits uninterruptedly, never denied anything, never withheld anything, and they did provide the quick and efficient delivery of medical and indemnity benefits as is required under the statute under 440.015 as pointed out by appellant.
Where do we get that the fees are not recoverable unless they are in pursuit of the rights? And I don't mean the Lavoie case itself, but where do they get that from in the statutes, that they're limited in that way?
And by they, Your Honor, do you mean appellant?
No. I mean us, anyone. From where do we get that rule that this is only recoverable if it's in pursuit of compensation claims? Where did Lavoie get that from?
That's a good question. And I think the Lavoie got it from Charlton. I think in the Charlton case, when it says collection of benefits, obtaining medical services, and representation,
Okay, maybe you know what my next question's going to be then. Where did Charlton get it from?
well, Your Honor, that's a good question. I think that there needs
I
to
mean,
be
I
a
just want to
nexus.
know where, we have these case law requirements, but I want to know how they fit in with the statutory scheme rather than just what the cases say.
Well, there is no statutory scheme for imposing guardian fees on an insurance company. 44017 says nothing about who pays for the guardian, who has to pay to establish it, or even who has to establish it and set it up in the first place.
Okay, so perhaps those requirements are related to the costs provisions that can be collected in under a 440 action?
Well, and I think that's an analogy appellant tried to make, that the judge of compensation claims erred in imposing some sort of a new test, that it's a prevailing party type of argument. However, the judge of compensation claims said in his order that there was simply no evidence that benefits were denied or that the guardian was instrumental in obtaining any benefits for the claimant directly related to the case. The judge of compensation claims never said in his final order anything about guardian fees being payable only if litigation ensues or if a petition for benefits is filed, or that the benefit had to be expressly denied by the insurance company. The judge of compensation claims never said that in his order, and therefore he did not impose a prevailing party analysis or make this analogous to a taxable cost against a prevailing party in a workers' compensation matter. The judge never took it that far. The
Well,
judge-
let's take a step back a little bit from the word benefit, right? So you don't quarrel with the fact that this incapacitated ward certainly needs someone to look after his financial affairs and to check in on him to ensure that to have an advocate for his medical care. You don't quarrel with that, right?
No, I don't quarrel with the fact that Mr. Lopez is incapacitated. He's in a vegetative state with no brain activity.
And he needs someone to look after his care. I mean, the statutes clearly provide that. So that there's certainly a benefit to having someone look after him, again, take care of his financial and medical needs. It seems to be that your argument is that that is not a workers' compensation benefit. Am I understanding you correctly?
I would not categorize it as a quote-unquote benefit, no. 44017 does allow for discretionary appointment of a guardian or some other person. It doesn't even have to be a guardian. It can be a representative or a designated person by the Department of Financial Services or the Judge of Compensation Claims. But what there is not found in the statute is any duty of any party, whether it be the insurance company, the judge, the department, or even the injured worker's family to appoint a guardian under Chapter 440. 44017 is discretionary, and the Florida Supreme Court has commented on that as well in the Allure Shoe versus Limberis case, that appointment of a guardian is discretionary in workers' compensation matters. So there is nowhere in the statute that requires the insurance company to do so. And as a practical matter, when an injured worker, and as the record evidence shows here, when the injured worker sustained his injury, the insurance company immediately tried to find out what was going on. When these things happen, the insurance company has to undertake an investigation. They obtain the medical records, they find out what the injury is, they find out what's wrong with the injured worker. The insurance company spoke with a family member who represented to the insurance company that, at least at the beginning, he would be taking care of everything, and that family member lived with Mr. Lopez. So the insurance company did what the family requested. The insurance company issued benefits, and within 1 month of the industrial accident, appellant's counsel filed a notice of appearance on behalf of the injured worker. We had attorney representation within a month of the accident. So appellant's argument is that the insurance company had some sort of duty, which is not found in the statute or any case law, to petition the probate court in Hillsborough County to obtain appointment of a guardian, and that just doesn't exist in the law. I mean, an insurance company is not in the business of representing an injured worker in court. An insurance company is not in the business of seeking a guardianship regardless of the wishes of the family or anyone else as to what they might do, but yet that's what appellant proposes the insurance company should have done. An appellant also proposes that a guardianship, and I think the court alluded to this earlier when they were asking questions of appellant's counsel, it's a chicken or egg situation. If we're to require a guardian because, as appellant contends, the incapacitated worker cannot possibly receive a medical benefit or an indemnity benefit without a guardian, then under that logic, a guardian would have to be appointed before any benefits could be provided to the injured worker, monetary or medical or otherwise. That seems to fly in the face of 440.015, which requires the quick and efficient delivery of benefits to the injured worker, which is
All right,
exactly what the insurance company did in this case.
Let's return to the statute at issue 44017, and maybe explore maybe where Charlton got the securing the benefit rationale. That provision contemplates the appointment of a guardian, and it says to, quote, receive compensation payable to such person under this chapter. What do those words mean?
Your Honor, I read those words to mean compensation in terms of compensation benefits, indemnity benefits.
And is compensation defined under chapter 440?
It is. It's governed by section 440.15 in terms of indemnity benefits.
Okay. Thank you.
And 44017, Your Honor, is absolutely silent as to who pays for the guardianship. It's silent as to who establishes the guardianship, who maintains the guardianship. It's silent. It doesn't impose a duty on anyone to set it up or pay for it. And again, it's discretionary by the judge of compensation claims. The judge of compensation claims didn't feel it necessary to appoint a guardian in the first hearing that was conducted in this matter on February 15th of 2021. In fact, the judge of compensation claims indicated during that hearing that he was concerned that he wanted some family involvement as to what's going on going forward in this case. Furthermore, appellant was represented by counsel within a month of the industrial accident. So what appellant is asking this honorable court to do is to add things to 440.17 that just simply does not exist in the statute. There is no requirement that the insurance company seek out appointment of a guardian. There's no requirement that the insurance company pays for it. And there's no requirement in the statute that the insurance company unilaterally pays for all guardianship services no matter what. Therefore, Your Honors, we're left with two things to focus on. One, the judge of compensation claims committed no error regarding his construction of 44017 and the Charlton and Lavoie cases when he denied payment of guardian fees in this matter. And two, the judge of compensation claims got it right when the appellant failed to meet her burden of proving that she pursued or obtained any benefits on behalf of Mr. Lopez. And therefore, this honorable court must affirm the judge of compensation claims' final order.
Thank you, counsel.
Thank you, Your Honors.
May it please the court. Fundamentally, Your Honor, the question is this supposed to be a claimant monitored system, a claimant's family monitored system, and an attorney for the claimant monitored system? Or has our case law told us for the last 40 years this is a carrier monitored system? It's exactly what it is. It's a carrier monitored system. And so the carrier here cannot construct a willful wall of ignorance and put their head in the sand and say, hey, we're just going to send you your checks to whoever and provide whatever medical care. There is nobody legally who is able to receive those checks. The claimant is an incapacitated person. I want to speak quickly to the preservation of error argument. All of these points were argued in a meaningful way before the judge of compensation claims. Preservation of error rules exist to prevent somebody from raising something for the first time on appeal that's not been argued meaningfully before the JCC below. That didn't happen here. It's kind of a red herring what the appellees have thrown at you. And insofar as the motion for rehearing, the rule specifically says it is, number one, to challenge rulings that were outside of the scope of the issues presented. That has nothing to do with this case. Or number two, to seek clarification in matters of law that the JCC may have overlooked. The JCC didn't need to clarify anything. He was very clear about what his position was. So if you look at the body of the rule, in addition to the rule saying, don't re-argue points you've already argued, which is exactly what the invitation of the appellees is to properly preserve error, which would do nothing but invite sanctions, I would humbly submit to you that this is not a preservation of error case. The question was asked, and I think it's a good one, Judge. where does sort of the authority for this emanate from, right? We know it starts, it's most recently Avoy, and then it goes back to Charleston. And so the question becomes, where did Charlton get it from, right? And Charlton got it from, two key points. Number one, Charlton talks about the cases which construe the statute speaking strongly in terms of the judge of compensation claims obligation to ensure that the interests of the mentally incompetent or persons are protected, number one. And number two, the overriding purpose of the Workers' Compensation Act, and we've talked about this almost ad nauseum, both before the JCC and as part of our brief, that you have to place benefits in the hand, that 440.015 requires that the carrier deliver benefits into the hands of the injured worker. You cannot deliver benefits into the hands of an incompetent person. Without a doubt, without question, Mr. Lopez needed a guardian to receive those checks and to make those medical determinations. And so the issue in this case is not whether the carrier should have went out and got a guardian or not. That's a conflating of what the issues are. The issue of who bears the primary responsibility for establishing and paying for a guardianship that is necessitated as a result of the compensable injury so that the claimant may receive his benefits, and so then the guardian may exercise all of the statutory directives. Your question, Judge Rowe, does it pertain just to indemnity? No, it does not. Section 440.17 talks about the judge of compensation claims may require a guardian to exercise the powers, and that's to receive compensation benefits and to exercise the powers granted to or the duties required of such person under this chapter, right? Those powers granted to this person are to get medical care. So the guardianship obligations under the statute aren't just confined to medical care only, indemnity. They are also confined, apply to medical care. And with that, Your Honor, we respectfully would submit that the judge of compensation claims erred by denying all of the guardianship costs, fees, and expenses, and must be reversed on those grounds. Thank you.
Thank you, counsel. Thank you both. This court will stand adjourned.